Good morning. This is Judge Elisa Perez presiding over the 210th District Court Civil Docket for May 8th, 2024. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Nunez, will you call our first case, please?
Calling docket 2023 David Charles Victor 0783.
That's TD Bank USA NA versus Ana Maria Treviso. May I have announcements, please?
Samantha Galvin for plaintiff.
Ma'am, we kind of lost your audio there.
Samantha Galvin for plaintiff.
Eric, are you okay with that? Yes, okay. Do we have any communications from Ms. Treviso? No. Ms. Galvin, what's going on this case? We're set for a status.
We have a settlement. We're just waiting on the documents from the defendant.
Is this the one that, give me a second. Right. Yeah, you all filed a motion for continuance. If I'm not mistaken, it's the same motion for continuance that has been filed once, twice. This was set for a motion to retain back in February, and I'm not seeing any change. I'm not seeing any updates. I mean, it's the same. We're waiting on settlement documents as the motion for continuance in March. So why should the court keep this on the docket?
I mean, we can move forward with the default judgment. We're just wanting to get the agreed judgment, and we're just waiting on the defendant to send it back to us. They've been making the payments on the settlement. They just have not yet sent it back. We've reached out to them. We're just waiting on them to physically send it to us, and they're taking time doing that since they're not represented.
I'm going to set this for a dismissal in 2 weeks.
Okay, I'll make sure we get everything sent in by then.
Thank you very much.
All right, maybe
Okay.
excused.
You may have a good day. Who's
All right,
next?
thank you.
Judge, we have docket number 2023 DCV 1564 JT Morgan Chase Bank versus Jonathan L. Wagner. Announcements, please.
Good morning, Your Honor. Samuel Sprouse appearing as local counsel on behalf of the plaintiff, J.P. Morgan Chase Bank.
And Megan Diach, that's D-A-I-C, on behalf of the defendant, Jonathan L. Wagner.
Good morning. Again, this is set for a scheduling status conference. Do you all need a trial setting, or what are we doing?
Your Honor,
Plaintiff
I think, yes, I apologize. I was going to agree. I think, because I'd already mentioned before to my client that we need to discuss resolution. I think that having a trial date would be helpful to push that and hopefully finalize a settlement.
Well, let me make sure. Okay,
And Your Honor, I was instructed.
Go ahead.
I'm sorry, I was going to ask for a bench trial setting about 60 to 90 days out. I don't think it'll take even a half hour. It's just going to be admitting business records from the plaintiff's perspective.
Okay, so let's go ahead and do that, Ms. Hernandez. Likely to be on a Monday. Are you all going to want to do that via Zoom?
That would be great, Your Honor.
Preference, Your Honor.
Okay. If we can accommodate Wednesday, our regular civil trial day, I'll do that. So we'll look at both a Wednesday, or if we have to, a Monday on Zoom. And we can get you set, and we'll send you the setting. Thank you very much. Bench trial in 60 days.
Thank you so much. May we be excused?
You may. Have a good day.
You too. Thank you, Your Honor.
Okay. Who do we have in the waiting room, Mr. Nunez? Just Mrs. Esparza?
I don't believe we have anybody else waiting on the other ones, Judge. The 0717 has been settled. And I haven't checked anyone else in for, I believe, the other one.
Esparza will probably be here for 3787.
She's logging in right now, Judge.
Mm-hmm. Okay. Mrs. Esparza, I went ahead and let you in because we're getting ready to start a kind of lengthy hearing, but I do not see Mr. Downey. Is someone here on behalf of Ankur Patel on cause number ending 3787?
I've been emailing him, Your Honor, so he should be on soon.
Is this the one where we have the, we're trying to select Or were you all gonna go to AAA? Is that this case? I'm trying to remember.
Yes, Judge, and we just emailed a proposed order to the court a few minutes ago, an agreed order submitting the case to arbitration.
Okay, Myrna, do you have that? Yeah, I just assume not, have you all wait because I know we're gonna take a minute on a couple of other hearings. So if we need you back, Mrs. Barcel, we'll go ahead and give you a call. Okay,
Okay, perfect. Thank you, Judge.
thank you.
Bye-bye.
And we can let Mr. Downey know the same if he logs in. But let's get started back on page 1. Thank you, Mrs. Barcel, you're excused.
Thank you, Judge.
All right, calling cause number 2021 DCV 3996, Paseo del Este Municipal Utility District number 1 versus the City of El Paso et al. May I have announcements, please?
Ryan Green on behalf of the plaintiff, Paseo del Este Mud number 1. And also with me are Harold Davis and Jeff Kirschbaum.
Good morning.
Good morning.
Morning, Your Honor. Stephen Weller on behalf of the El Paso Water Utilities Public Service Board, and also have Sarah Labashowski here from my office.
Good morning.
Good morning, Your Honor.
Morning, Your Honor.
Okay. So we are scheduled today, well, final judges conference, but I feel like the motions hearings are more of why we're here. I had a couple of pleadings filed that frankly, I'll tell you, I have not seen. I want to say these were filed yesterday, but let me just double check. I was looking at hard copies and didn't look. Correct. The supplement, there's an affidavit, an opposition, some responses. So let's start. Wow, Mr. Weller, where do you want to start?
Your Honor, I think the principal matter before the court is the motion to award attorney's fees filed by PDE. Our response brings up something at the beginning, which is that there are some pretty clear legal problems with this request for attorney's fees. Our suggestion, respectfully, is that the most efficient way to handle it would be to take up those legal matters first, because if the court resolves those, they would completely handle the matter of attorney's fees. We're here prepared to respond to the entire motion. So we're here to respond upon the reasonableness and necessity if the court determines that the fees are recoverable. But the court had indicated in a prior hearing, and I felt like there was a desire to wrap things up as much as possible in this hearing. So we're prepared to proceed on everything today. But I will say that whether attorney's fees are allowed is the legal question. And so I feel like that is the most efficient way to proceed forward.
All right, Mr. Green, are you gonna take that?
So, Your Honor, we have 2 motions set for hearing today. One is just a motion for leave to amend the pleading. And then the other one, as Mr. Weller said, is a motion for attorney's fees. However, and I agree with Mr. Weller that the motion for attorney's fees is the bigger deal as far as length of time, substance, and all of that. So as Your Honor will recall, plaintiff prevailed on summary judgment on how the EP Water was incorrectly doing the billing under the contract. And so then the remaining question on our claims is whether we as plaintiff are entitled to recover our attorney's fees as a result of that ruling. The issue, though, is that you can do attorney's fees by submission on the motion, motion responses, those sorts of things, or do it by an actual evidentiary hearing when you have a witness giving testimony. I filed the motion for attorney's fees and set it for the hearing under the possibility that we could do it by submission, that we could just do it by argument. But defendant filed a responsive affidavit yesterday, as Your Honor alluded to, that essentially creates a fact question on the issue of reasonableness and necessity. So in order for us to get our fees, we have the fact question of are our attorney's fees reasonable and necessary? And then we have the question that's under the discretion of the court. Is it equitable and just to award us our fees? That requires us to put on evidence. We submitted an affidavit. Here's the evidence. Here's our billings. But as I said, defendant submitted a responsive affidavit that challenges the fact that on those factual points, the reasonableness and necessity. So I think what has to happen at this point technically is we need to actually set a hearing, an evidentiary hearing, where we'll have Mr. Davis take the stand and give testimony in support of the reasonableness and necessity of the fees. If defendant wants to put on a witness, they can do that as well. And so that's where I think we are. I know that Mr. Weller wants to argue legal points about this. And whether or not Your Honor wants to take that up right now, as far as the actual factual issue to resolve whether we should be awarded fees and what the amount of those fees would be, we're going to need to get an evidentiary hearing set. Go ahead.
Is that not what we're set for today?
Correct.
I have a set for, there's a setting for a motion hearing. The notation there is on the motion to award attorney's fees.
Right. And so if we're going to go and do that today, and then we would have to put Mr. Davis on the stand. Right now, the problem with doing that is, as Your Honor alluded to, we just got the responsive affidavit filed yesterday. We haven't had full time to digest it. And like I said, it raises some factual points that would require some additional work. And so I don't want this to be a long time from now, because I do agree with Mr. Weller that we do want to get to finality on this. And so, but I think that's where we are. If we're going to need testimony, we're going to need a reset of the motion for fees on that reasonableness issue.
Okay. So I have not, I have your supplement, Mr. Weller, but frankly, I have not reviewed it. So the affidavit is 4 pages. I saw you shake your head when I basically heard a request for a reset. So tell me, please, Mr. Weller, but you have a disagreement in terms of a reset on that motion. We are set for that today. That we did not. I can go back and look at the order of court setting. Probably had been set for about 2 weeks. Mr. Weller, in terms of a reset.
Yes, Your Honor. The motion for attorneys. I mean, this hearing's been set for. As the final judges conference, it's our trial date, effectively. It's been set for a month or so. The motion for attorney's fees was filed last week, and we turned around and very quickly prepared a response on all the legal issues, all the equitable issues. So yes, I did file a supplement yesterday, but it's because I got the motion last week.
Got it.
So, I mean, my understanding was that we were going to proceed on matters today. And so that was, that's why the hearing was set as I gathered it. Usually when, I handle attorney's fee matters, we don't have to have live testimony. That's what the affidavit is for. So Mr. Davis has provided an affidavit attached to his motion. He's laid out why they think attorney's fees are necessary. And we have responded with our own affidavit, which is, the points are pretty simple, which are that the fees that they're seeking $350,000 worth of existing fees and another $180 for appeal. And the issue is, in our response is pretty simple, is that a huge percentage of that seems to relate to claims that PD filed and they didn't prevail on, or claims they made to the Public Utility Commission rate appeals that are not recoverable, or a matter that came up regarding some undisputed payments that PD has paid now. So they've just kind of thrown the kitchen sink at the request for attorney's fees, and it's not proper to do that. They're supposed to segregate them out to remove the fees that are not appropriate, and then the fees for future appeals and so forth are unsupported. So I think there are some very glaring problems with the submission of attorney's fees before the court today. And I think that's probably the reason why there's a request to split it out. But we've taken the time to respond to the attorney's fee submission with the understanding that we're going to have a hearing here today. And so I just would rather not have to go back and respond to yet another request where they sort of reinvent their request.
Your Honor, Harold Davis, can I pipe in? I will tell you, not only was a supplement filed yesterday, but the response was filed yesterday, raising all the legal issues. So we haven't had a chance to even respond to those.
Well, I'm just thinking overall, this has been set fairly quickly, so everybody's kind of rushing to get to be prepared. I think it's a quick turnaround. If the motion was filed only last week, it's understandable why we would have, I don't really consider it last minute responses, supplements, things of that nature the day before what is a scheduled hearing, because it seems like we have scheduled, it appears to me that the hearing is premature because there is a lot involved here. At the very least, we probably should have set this maybe 3 weeks out so everybody could have a chance to respond, reply and respond. I don't know, all of those different things you all would do in anticipation of a hearing. And Mr. Green, what I'm also hearing you say is that you are making a request, I guess your initial understanding was that this would be reviewed basically via submission, but now is it a request that we have a hearing with testimony on the attorney's fees, or given more time, I can take it via submission?
Yes, Your Honor. The request is to have an evidentiary hearing, and here's why. It's not that I'm surprised by the legal issues. The issue is that a controverting affidavit was filed, and I don't think this court can decide as between controverting affidavits without live testimony. So once that happened, once that raised the issue, I think the court needs to see live testimony but like I said, the fact that we didn't get the affidavit yesterday, and so it's those factual disputes that makes me request, all right, well, let's get an extension to deal with that. So I can do the legal arguments whenever, but it's the factual fight that would require an evidentiary hearing that we would like a reset to handle that.
And you dispute that, Mr. Weller?
Your Honor, I think again that this issue can be decided on the legal issues. Mr. Green is saying that those are not surprise or anything. I think if I may suggest, let's proceed with the legal matters, and I think that will resolve the potential need to have an evidentiary hearing. I don't think we need an evidentiary hearing, but I think that the legal issues will resolve this quite clearly. And so we could go forward on that, and I think that would be an efficient way to proceed.
Okay. Well, I think based on what we have right now, I think I'm not quite in agreement with that. Having, and I don't really, fault you, Mr. Weller, for having a, yesterday response affidavit filed, not at all. But I think the proceeding would be better served to have a little more time. And then we do have a full-on hearing. Mr. Green, if he wants to call witnesses, do all those types of things, we'll do that. So I want to make sure, though, that we're not in the same posture. The court schedule is very tight for this month. I would like to make sure that as quickly as I can get you all reset on this, that we're not in the same boat. So in 2 weeks from now, that if you all are, filing things back and forth, that we again don't have this kind of last minute, well, here's something else, so that we're not delayed any further. I just told Myrna yesterday not to schedule anything else for May. And here I'm gonna turn around and say, we need to find a spot in May.
Your Honor, I've got a very booked May. If we can push this out to the second half of June and under the agreement that we're not going to ask for any further extension of time on that. I have a ridiculous schedule over the next month, and I could go date by date with everything that's happening. But if it would be possible to get this into the back half of June with an agreement, that's the setting. I would personally very appreciate that.
That's much farther than I was planning to go.
Understood.
So, okay, Myrna, forget what I said yesterday. What do we have that last week of May? And the only reason I'm going that far is because I know we're out of pocket in trial like next week through the end of May. So do we have like May 29th? Is that a workable day?
Judge, in looking at the docket for the 29th, it's a full civil docket already. Good morning.
Mm-hmm. Okay, in the afternoon, we have a tax docket, I would imagine.
Your Honor, if I may, let me check something on my schedule just really quickly.
Sure.
I could do the 29th. I have travel plans the week before, but I could do the 29th. The part of the issue I have, and I certainly respect the court's decision on this, is that we've already prepared a full response, and we did so quickly based upon it being filed last week. So I'm concerned that we're going to be reinventing the wheel again on whatever it is that PD files on this, because they've really been scrambling to try to move their pleadings around and justify this attorney's fee request when it's just legally flawed, just period. According to the Texas Supreme Court and a whole lot of courts of appeals. So it is if we're going to proceed, then it would be nice if we're not going to be having to answer to brand new presentations of requests and else.
I wholly I am going to set a deadline for PD to file anything in anticipation of that hearing, because for my purposes, you know, I'm not going to say it's totally closed today now with your response. Basically, Mr. Weller and Mr. Green, what I'm contemplating is that plaintiffs will have a deadline to respond to what you had filed yesterday, Mr. Weller. That deadline will be the 17th, if we're going with the 29th date. And then Mr. Weller, anything you needed to file, just have it filed by the 24th. Everything closes at that point. Okay, everything closes at that point, and anything else you want to bring up based on those responses, we'll hear at the hearing.
Your Honor, can I ask a clarifying question on the 29th? Could that be because there needs to be live testimony? Could that be in person?
Sure, I can. If you all want to do it in person, we can do that.
Okay.
Yeah, it would have to be at 3 o'clock. It would have to be either at 3 p.m. or at 8 a.m.
3 p.m. As between the two would certainly be better. I've got a full day of mediation the day before. I have a significant deadline on the 29th. So if it were possible to push it to the 30th or 31st, that'd be great. If we need to do it on the 29th, then 3 p.m. would be preferable to me.
Mr. Weller, what does your schedule look like for the 30th?
Your Honor, I'm going to be out of town.
Okay.
On a trip from the 22nd to the 26th. I'm going to Kansas City for an event for my daughter.
Yeah.
So if I
Mr.
guess
Weller, let me stop you real quick. The 30th, the court is specially set in a jury trial on the 30th. So 30th is out. Yeah. Yeah. My schedule is bad too.
Is the 31st open with a jury trial potentially going to the 31st?
No, once we start on the 30th, we'll be out of pocket again, which, you know, that all gets me to, now we're looking at June. Not likely, if I'm not mistaken, it's a murder case, not likely we would be done by the 5th. So now we're already going to like the 10th, assuming we're not in trial from the 6th. So I think the 29th might be that window, right?
Okay.
That window that we can take advantage of.
I think 3 p.m. on the 29th.
In person?
Yeah.
Okay.
If I may make one request.
Yes, sir.
So I'm going to be out of pocket for the second half of that week of the 19th, 22nd through 26th. I'm going to be out of town.
Okay.
Could we make PDE's deadline maybe the 14th or 15th? So I'm not having to coordinate with my associates while I'm on this
Sure.
with my daughter.
So we're gonna back it up. It'll be PD's deadline is the 15th. Mr. Weller, I'm gonna assume you have your own deadline of the 22nd. That'll be my deadline, but I guess that's when you start your trip. So we will have everything closed out by then in anticipation of our 29th hearing in person. Okay? All right. So then what's left for today?
So plaintiff has the motion for leave to amend pleading.
Thank you, counsel. All right. While I pull this up, Mr. Green, you may proceed.
Okay. So I'll go ahead and share my screen because I think that'll make it most efficient. And so the motion for leave, this is, we had a pleading deadline in the case of mid-December of last year, which is why we need to file the motion for leave to do this. The basis for the motion is there was a typo in our live pleading, and I viewed it as a pretty significant typo. And so in our motion, just right there on the first page, this attorney's fees and costs paragraph that's in the current pleading, the live pleading, fourth amended, says that we're seeking attorney's fees under section 31.009. There is no section 31.009 of the Texas Civil Practice and Remedies Code. It's section 37.009 is what that's supposed to be. That was a slip, I assume, of typing numbers on one of those number pads on the keyboard. So since obviously we are our big issue now from the plaintiff's perspective, now we're just looking at attorney's fees. We wanted to get that corrected. And so that's the purpose for it. And then I'll just walk the court briefly through the existing pleading as far as its structure and what we're doing as part of this motion for leave. And this, I won't belabor this, but just so that the court can see it. So on the screen right now is our live pleading. This is our fourth amended petition. Under discovery control plan, we say all we're asking for is non-monetary relief, but as well as attorney's fees. And then when we get into jurisdiction, there's the correct site, the UDJA, the Uniform Declaratory Judgment Act, Texas Civil Practice and Remedies Code, Chapter 37, not Chapter 31. The pleading has a whole lot in it as far as background facts, as far as different theories, as for why the city can't charge the rates that it has been charging. As you can see, I'm scrolling through this extensive factual background, and then you get to these different theories right here on page 15. It's illegal, violates the contract, illegal, unconstitutional, etc. Then finally, you get to the claims for relief, and here's what we've actually been seeking all along: declaratory judgment claim. And that was the subject of our motion for summary judgment. Declarations regarding the fact that EP Water is overcharging us. It can't charge us the 10% surcharge. It can't change the peak rate calculation. So Declaratory Judgment Act under the UDJA. We also had injunctive relief. This is on these claims of illegality. We non-suited those. So in addition to a breach of contract theory under which our declaratory judgment claim was based, saying, hey, they're violating the contract, we need declarations as far as what the contract means, we also had this theory that what they're doing also violates statutes. We non-suited all that to make this case just about the language of the contract. And then lastly, seeking attorney's fees, and there's that typo. It should be 37.009. So what we've done for the amended petition, and so now I've got on the screen what would be our fifth amended petition, were the court to give us leave to do that, is we've done two things. Number one, we fixed the typo. It will now say 37.009. And number two, we removed all of the allegations, illegality, that had already been non-suited. And the reason for that is because if we file an amended petition that keeps all of that stuff in there, the effect would be we would be reasserting it post non-suit. We don't want to do that. And so this is just basically, we're amended the pleading solely to fix the typo, but along with that, we needed to clean it up and get rid of everything that was non-suited. And so this time, if I scroll through, the court will still see this very lengthy factual background. But by the time we get to where before there were all these theories of illegality, we skip all that. That's now gone. Claims for relief, very straightforward. Declaratory Judgment Act still based on what the contract actually states, and attorney's fees, and there's the fixed section. So that's it. That's all we're doing. We just want to make sure that the record is clean on everything we're doing is under the UDJA, the Declaratory Judgment Act, and if the court granting leave, it will just conform essentially the pleadings to what our claims have always been. And so that is the request. And does Your Honor have any questions?
No, sir. All right, Mr. Weller.
Thank you, Your Honor. So I'm glad we're going to have a chance to discuss this, because this is going to give us an opportunity to get really right to the heart of this whole problem with their attorney's fee request. There are multiple issues with this request for leave to amend, and we heard Mr. Green tell us several times just now that it's a non-substantive change, is what he said. He said it was to correct a typo. It is quite a lot more than that. It is an attempt to make a post-judgment amendment to their pleadings to drop their contract claims, which are alleged in their live pleadings. And I'll walk the court through the Fourth Amendment petition. Mr. Green said we need to non-suit the claims, that all the illegality claims. The motion for leave says we're going to non-suit the illegality claims. And what it's really doing is it's trying to position their pleadings and rearrange their pleadings post-judgment to work their way around a very well understood, very well established rule in Texas, which is that you cannot use the UDJA attorney's fee statute to plead around the attorney's fee limitations that apply to contract claims, which is what this is. There have been holdings from the Texas Supreme Court on this. There have been holdings from virtually every court of appeals in Texas on this same proposition. So it's an attempt to clear out their pleadings, as Mr. Green just said, but it's an attempt to clear out their pleadings to make it look like they don't have a contract claim, which, according to very well established law, operates as a legal bar to the ability to seek attorney's fees under 37009. So if I may share my screen here, Your Honor.
Yes, sir.
Can you see, does it say EP Waters response and objections on your screen there, Your Honor? Oh, I haven't shared yet.
Yes.
Okay. So we've explained in this response what this pleading amendment is all about. There is a long line of cases I've said that it's well settled a party cannot recover attorney fees pursuant to 37009 if the claim for declaratory relief is merely duplicative of or incidental to another claim for relief under a contract. So basically what the courts have said is you cannot tack on a substantively identical or similar UDJA claim in order to take advantage of 37009, which is a very different standard for getting attorney's fees. 38001 is the standard that applies to contract actions. And it says, let me find this. It says that you have to have, let's see, Okay, to recover damages under 38001 for an oral or written contract, it's mandatory that a party show two things. They have to show that they prevailed on the cause of action, and they have to show that they recovered damages. PDE did not recover damages in this case. They held on to these disputed payments. They never made those payments. Their pleadings affirmatively tell the court that we're seeking non-monetary relief. So they cannot recover under the proper vehicle. They cannot recover under 38001. So they've tried to do something that many litigants have tried before them, which is to make use of 37009 of the Civil Practice and Remedies Code, which is the standard that governs attorney's fees for a UDJA claim. And 37009 does not have the same requirements that 38001 has. It says that the award of attorney's fees is discretionary, and that the court has very broad discretion to grant fees to the party that wins, to the party that loses, or to nobody. So it's a very different standard. If you seek under 38001 and you show both those elements, it's a mandatory award of attorney's fees. But under 37009, it's a very different standard. So what this pleading amendment is about, what they've done here is they are, let me see if I can see. The leave to amend would drop the claims that they've already non-suited. So I'm not sure why you need to drop claims that they've already non-suited. They don't need a pleading amendment to drop claims that they've already non-suited. What they're trying to do is you get down here to the fourth amended petition. Here's the fourth amended petition, Your Honor. These are their active pleadings. There are all these causes of action, the 10% surcharge and illegal tax, and then you get down here to breach of contract. So these are their live pleadings. They've stated plaintiff incorporates all the allegations set forth herein at length. The PSB has breached the terms of wholesale contract by the use of the unauthorized methodologies. As a result of the defendant's conduct, the plaintiff has accrued attorney's fees for prosecuting this action. They go on to allege causes of action for illegal exactions, unconstitutional takings, and then I guess Mr. Green is trying to say these are their claims for relief in the DEC action, but the parties have been litigating breach of contract exactions all along. So they non-suited those causes of action. They're clearly causes of, here's their non-suit. We're taking a non-suit with prejudice of the causes of action against defendant for illegal tax, illegal exaction, impact fee, unconstitutional takings. So these are all these allegations right here. These are causes of action. There is a breach of contract cause of action. There was an exaction cause of action that they non-suited. Mr. Green's motion for leave calls them that if we were to not remove them, they would reassert it as causes of action. So I'm not sure how he's saying the contract claim is not in a cause of action. See if I can find my, okay. So here's what the case law says on this point. This is a decision out of the Texas Supreme Court. Texas has long followed the American rule, prohibiting fee awards unless specifically provided by contract or statute. So unless it's provided, allowed under the contract or allowed via statute, they can't get attorney's fees. Then the court goes on to say, by contrast, the Declaratory Judgments Act allows fees awards to either party. If repleading a claim as a declaratory judgment could justify a fee award, attorney's fees would be available for all parties in all cases. That would repeal not only the American rule, but also the limits imposed on fee awards and other statutes. Accordingly, the rule is that a party cannot use the act as a vehicle to obtain otherwise impermissible attorney's fees. When a claim for declaratory relief is merely tacked onto a standard suit based upon a matured breach of contract, which that's what this is, allowing fees under Chapter 37 would frustrate the limits of Chapter 38 imposes on such fee recoveries. And granting fees under Chapter 37 when they're not permitted under the specific common law or statutory claims would violate the rule that specific provisions should prevail over general. So what they're saying is if the legislature has established a rule for getting attorney's fees, which they have for a contract action, 38001, you can't substitute in this different, far more lenient standard. because otherwise there would be no purpose to having a rule for how you get attorney's fees. So, Your Honor, this is a list of cases from different courts of appeals that we just pulled out of the case annotations of 37009. And you have the Supreme Court, the El Paso Court of Appeals, Beaumont, Texarkana, San Antonio, Fort Worth, Austin, both Houston districts, all saying the same thing in one way, shape, or form or another. A party cannot use the Declaratory Judgment Act as a vehicle to obtain otherwise impermissible attorney's fees.
Would you slow down a little bit, please, Mr. Waller?
Sure. So parties have tried this through a variety of different methods. Sometimes they'll have a deck action claim standing right beside a contract claim, which is what we have in this case. Courts have said, look, if you assert a deck action that is substantively identical to a contract action, that's you can't do that either. Even if it's asserted by itself, that doesn't work either. Courts have said that is considered an that you're only asserting the deck action to try to get attorney's fees. And the courts found that that's an abuse of discretion. So this is a case right here that's cited in our response. It is an abuse of discretion to award attorney's fees under the UDJA if the claim for declaratory relief is urged solely as a vehicle to obtain attorney's fees. So what Mr. Green is telling you is that they alleged only a UDJA claim, which is not true, and it's substantively identical to their contract claim. But it is an abuse of discretion to award fees under this scenario. So that's sort of the legal background. And that's the reason they're trying to clear out their pleadings. They're trying to distance themselves from the idea that they had a contract claim. Then they're doing so post-judgment. So we've gone through this whole litigation, litigating all the claims listed in their Fourth Amendment petition. We filed a motion for summary judgment on these exaction or impact fee claims, unconstitutional takings claims. They've been treated as causes of action the whole time. PDE filed a notice of non-suit of the causes of action for illegal tax that Mr. Green is now saying none of these are actual causes of action, Judge. His motion for leave calls them causes of action. So this is a dead giveaway. They want to amend their pleadings because they don't want the contract claims there when the court goes to rule on attorney's fees. Because according to well-established case law, it is a bar to getting attorney's fees. Now, whether they clear it out or not, we all know what the case is about. We all know it's a contract action. And the request for declaratory relief down here, Your Honor, seek the same thing that a contract claim says. Right here, this is their request for declaratory relief. The PSB has breached the wholesale potable water sales contract. That is no different than a contract action. It's the same thing. So here are the issues with and why we oppose the motion for leave to amend. One, it's way past the pleading deadline that we agreed upon, which was last December. It is a very obvious post-judgment attempt to fix their pleadings. So, because they know that if we have to go up on appeal on the attorney's fee issue, that the Court of Appeals is going to look at it and say, no, there's a long line of case law saying you can't do this. And so they're trying to distance themselves from the contract case. And I'll note that the motion for leave to amend does not say that. They don't say we're trying to drop our contract claim. It says, where is it? It says what Mr. Green just said. He says it's a non-substantive change. It omits the part where they're dropping the contract cause of action. So, Your Honor, this goes to the heart of the issue that the legal issue that we're going to brief the court on today. It is legally impossible for PDE to get attorney's fees because you cannot, when you have a contract action, make use of a different statute. If you could do that, every party would do it in every case. So this principle has been applied across the board in many different causes of action. There are cases cited in our response where a party tried to do it when there's a Open Meetings Act allegation, and the court said there's no mechanism to get attorney's fees for that cause of action. So you can't tack on a UDJA claim to it so you can take advantage of the attorney's fee vehicle. The legislature told us, here's what you have to show in this cause of action to get attorney's fees. So if you could just tack on a UDJA claim, every plaintiff would do it. And there would be no reason for the legislature to have written those rules for when you get an attorney fee claim under breach of contract. So this is the reason why we are saying that you can't get attorney's fees. It's a clear attempt to plead around the correct standard. And it's way past the pleading deadline. And incidentally, legally speaking, there is no substantive difference between a DEC action and a contract action when they seek the same thing. So the UDJ is a remedial statute, which is out there to adjudicate claims that are primarily not mature breach of contract claims, meaning it's not a breach of contract claim where the breach is allegedly has already occurred. It allows parties to do things like, look at the terms of a statute or an ordinance or a contract and say, we have a pending dispute. We need a determination as to whether the parties can do that under this statute or contract. It is not written to replace a contract cause of action. That's not what it's about. And there's lots and lots of case law on that point too. So that's kind of our response. I'll let Mr. Green respond and then I can address any counterpoints, but basically that's where we're coming from. Understood.
Thank you, Mr. Weller. Mr. Green?
Sure. Mr. Weller, can you pull down your screen, please?
Sure.
Okay, so the only reason we're doing this is to fix the typo. This idea that we're secretly pulling down a breach of contract claim, that's just not true. We've never asserted a breach of contract claim. And here's why. To assert a breach of contract claim, one of the required elements for that claim is damages. We don't have monetary damages because we have been withholding the amounts that they were telling us we had to pay. We said, no, we don't have to pay those. We're not going to pay you those amounts. We're going to file a DEC action to get that determined. But because we withheld the payments, we don't have monetary damages to go seek. So from the beginning, Your Honor can go back and look at our original petition, every amendment. There's no assertion of a breach of contract claim because there's no assertion that we have any damages that could support a breach of contract claim. This case is a DEC claim from our perspective and has always been. Now, as far as this, well, let's start with the statute. I think what Mr. Weller is really doing is trying to argue perhaps in advance some of his legal defenses against our fee claim. We dispute his statements regarding the law, and let me just show real quickly what the statute actually says, because there was a whole lot said about the UDJA. The UDJA specifically says that a person whose rights are affected by a contract may have determined any question of construction arising under the contract and obtain a declaration of rights thereunder. And then this key phrase, a contract may be construed either before or after there has been a breach. So that's what's happened here. They breached the contract. We couldn't assert a breach of contract claim because we don't have damages. And so instead we sued to have the contract construed, to have its meaning declared. And that's what we did on summary judgment. And this, by the way, is the statute that allows for the recovery of attorney's fees under the UDJA, under the Uniform Declaratory Judgments Act. Back over to the actual pleadings. Again, all we're trying to do is fix the typo. But again, I'll show the court what we meant when we said we were non-suiting causes of action. All of that stuff before is part of background about the various things they're doing. Claims for relief is where the actual causes of action are pleaded. Declaratory judgment. And when we said we're non-suiting our causes of action based on illegality, those are different declaratory judgment requests. There's one, illegal, the statutory basis, illegal. That's what we were non-suiting. These are the actual causes of action. We've never asserted a breach of contract claim. We're not trying to deceive anyone on this. All we're trying to do is fix the typo. And remember, this is the live pleading, which is right here, 31.009. And by the way, Mr. Weller said that everybody's been fighting a breach of contract claim. We've never fought a breach of contract claim because we don't have damages. And here's the motion for summary judgment that this court granted. And just scrolling down to the relief, we're not asking for breach of contract claim success. We're asking for declaratory relief. That was under the UDJA. So it's just not the case that we've asserted a breach of contract claim and now we're secretly pulling it. All we're trying to do is fix the typo. From our perspective, this is a deck claim where we believe we're entitled to fees under the deck claim. That's what's going to be heard by the court at the end of this month. And if Your Honor concludes then that we're not entitled to recover fees, then we could have that argument then, but we certainly are going to be able to file a reply in a week, the deadline we were given, to show that no, we can recover our fees under the UDJA. We're legally entitled to. And so that's all we're here to do, Your Honor. Fix the typo. Like I said, I had to remove the other deck claims relating to illegality because otherwise we would have been reasserting what had been non-suited. And so we would ask the court to grant plaintiff leave to file the Fifth Amendment petition. I acknowledge it's several months after the deadline. That's why we have to ask for leave because we are in fact after the deadline. Otherwise, we can just file the amended petition. We didn't notice the typo until after we got the summary judgment ready to proceed to ask for fees and noticed, oh, that says 31, not 37. Let's clean up the record and fix that.
Thank you, Mr. Green. Mr. Weller.
Your Honor, taking those points in order. So Mr. Green's saying they don't have a contract action unless they have damages. That's not true. Okay, so here is the here's the MBM case. It is one of the seminal cases on this point. MBM Finance Court versus Woodlands Operating Company out of the Texas Supreme Court. It's a situation where a party to a contract, a copier or lessee, had no damages under the contract, UDJA and fraud claims. The court held that the lessee could not recover attorney's fees under the UDJA because although they obtained declarations, the declarations merely duplicated the issues already before the court in the lessee's contract claim, where fees were not available. So you don't have to have damages to assert a breach of contract. This Texas Supreme Court case dealt with a fact pattern that's basically identical to ours. I stated in my response to, sorry, I just shared my screen, but it's the MBM case versus Woodlands Operating Company. And this is where the Texas Supreme Court found a case is basically procedurally identical to ours. A party came forward, had no damages on a contract claim, and also asserted the UDJA and fraud claim. And the court said, no, you can't use the attorney's fee statute to get into the UDJA statute to get into attorney's fees. So, you know, the PD's motion for attorney's fees here, it states that it's because of a contract action. So what Mr. Green is trying to do is he's saying that, Judge, we're not making a contract claim. We're just making a UDJA claim that says it's a breach of contract. And that's no different. Even taking the facts as he alleges them to be, that it's no different. It's substantively no different. This is the exact kind of circumstance that came forward in the Southwest loan case, where a party filed mere declaratory judgment actions in response Duarte, Vera, Pardo assert their declaratory judgment counterclaim was properly raised because it presented issues the same as the contract claims that had already been made against it. And the court said it is an abuse of discretion to award attorney's fees under the UDJA if the claim for declaratory relief is urged solely as a vehicle to obtain attorney's fees. And then cites a case out of the Waco Court of Appeals. So, you know, Mr. Green is saying that he only needs it to fix this typo. Our response to their motion for leave said, look, we acknowledge that we know what you were talking about when you cited to 37001. That's fair notice to us. You don't need an amendment to address that. We've already said that in our response to their motion for leave. We've already said you don't need an amendment to remove claims that you already non-suited. They've already been non-suited, dropped out of the case. PD called them causes of action and dropped them out of the case. We don't need an amendment to do that. The only reason to do this is to try to clear out the appearance of a breach of contract claim, which it's not going to work either way. But we object to this post-judgment attempt to reform the pleadings, readjust the pleadings, to try to plead their way away from something that we all know to be the case, is that this is a contract action. It's a contract action about the interpretation of the contract. It's a contract breach claim. So
let me ask Mr. Green if what I hear Mr. Weller saying is everybody's on the same page or has the same understanding with respect to the typo. Why do we need an amendment?
Yes, Your Honor. I heard the same thing, and I appreciate that. My concern is that counsel's going to say that in the trial court and then change positions on appeal, which they can do as a governmental entities. You can't. There's certain. Well, actually, I haven't researched whether they can do that as a governmental entity, but that's the direct answer to your question. I'm glad that counsel has conceded that everybody understands that's 37.009 and not 31.009. I also heard counsel concede that it really doesn't matter either way if we do this amendment because they still have the same arguments. And so just as far as taking the most conservative approach, we would like the amendment, the fifth amended petition, leave to file that so that the docket is clear which statute we're citing to for purposes of appeal. As I understand now that for purposes of before Your Honor, that he's conceding, we are seeking fees under 3709. And so really that's what I have in mind. They've already told us they're going to appeal the summary judgment. I'm confident that if Your Honor awards us fees, they will appeal the award of fees as well. So that's why we're here asking for leave.
I think I'm good on this one. So I did want to look over the case, and then there was an El Paso Court of Appeals case that I saw on your list there, Mr. Weller, that I noted. McGahey, I think 603 Southwest 3rd, 515. Not having the full opportunity to sit down and read your pleading, I think I hear pretty clearly what you're telling me on this one today, but I do want to review it. So for my purposes, I'm going to ask for a little bit of patience because although I think I can do this quickly every time I say that, I'm also going to be traveling tomorrow. So I'm going to try and knock it out today, but if I can't, just bear with me because I will be out of pocket and in trial next week. But I'll do my best.
If I may, let me make a couple more points just because I was having trouble accessing my share screen here. One of the last points in our response is that PD has not shown a reason why its proposed amendment is necessary. The factors that the court can consider when considering a pleading amendment. So we have an agreed scheduling order, and we established a deadline for an agreed scheduling order so that everybody knows what the causes of action are and they can prepare and file dispositive motions before trial. And the factors the court can consider are how long has the suit been on file before the amendment was requested, how close to trial the amendment was filed, whether it's based upon newly discovered matters, whether the opposing party alleged surprise. We're absolutely alleging surprise. There are no new conditions here. There's nothing new that's come along.
Hold on a second. Hold on 1 second. I think we lost our court reporter at some point.
Yes, I don't know what happened. So you said, although I can do this quickly, and then that was off.
And I'm sorry, you're sharing your screen, but I'm also looking at your printed pleading. My apologies, Mr. Weller. I didn't catch that.
Sure. So what I was saying was that the third ground that we talked about, third opposition to this motion for leave, is these are the factors that a court considers when considering a pleading amendment past the pleading deadline. And the questions are such as how long has the suit been on file before the amendment was requested? How close to trial the amendment was filed? Whether it was based upon newly discovered matters, in other words, something that just came up, whether the opposing party alleged surprise. And here, this amendment is nearly 3 years after the litigation was initiated. There's no allegation of anything new. It's after summary judgment was rendered. So it's, when you have a case disposed on summary judgment, the summary judgment hearing is considered to be the trial, meaning this is a post-trial amendment. And PD is not really providing any reason, again, why they need this at this late time. They filed the pleading amendment within a few minutes of when they filed their motion for attorney's fees under 37009. It's pretty obvious that they've identified that this is a huge substantive problem, a huge procedural problem, and they're trying to work their way around, and they're asking the court to help them. So, I mean, another thing about their petition, Mr. Green is saying, this is all, their declaratory judgment action is their only claim. Here's what their claims for relief say. Plaintiffs incorporate all the foregoing allegations as it's set forth herein at length, which includes unconstitutional taking, breach of contract, plaintiff PSB has breached the wholesale contract by use of the unauthorized methodologies. As a result of defendant's conduct, plaintiff has accrued attorney's fees for prosecuting this action. It's a contract claim and a request for relief under a contract claim. It's a request for attorney's fees under a contract claim. So all we're asking, Judge, is that we not have post-judgment motions to amend the pleadings that we then have to go up to the Court of Appeals if there's an attorney fee award and say, Judge, and say to the 8th Court, say, yes, here's what their pleadings were when we took the appeal, but here's what they've been through the whole case. They've been alleging breach of contract through the whole case. We've been litigating breach of contract. I mean, how many times PD's motion for attorney's fees says this is a contract action? I'm kind of at a loss to a certain extent to respond to some of this, because it's like trying to reform the facts.
Gentlemen, I feel like I fully understand what we're talking about with respect to the motion for leave. So I am going to stay with what you all have filed. I don't need any more argument at this time. I will see you on the 29th for our in-person hearing on the attorney's fees. Please make sure you adhere to the deadline so that we can move forward. As I've mentioned, I can't really make it any more clear, and actually is part of why I need to move on here today. The court has a very, very busy schedule, as do you all. And so I don't want to shortchange you in terms of time for hearing, but we need to kind of stick to that March 29th setting and move on that. And like I said, I'll do my best to get this taken care of before I leave tomorrow, okay? Alrighty. That's it. That's all I need. Thank you very much, counsel. You'll have a good day.
Thank you, Your Honor. You too.
Hello, Judge. You want me to start everybody in for the second one?
Yes, let's Erica, you can, if you need a break, take it. Let's bring in those Medrano, that informal conference that we don't need to have on the record. So that's Mr. Rincon and everybody. Let me see, I can bring them in. Mr. Montoya, Ms. Vasquez, Mr. Soquet, Mr. Moss.
May it please the court, Your Honor.
My
good morning.
apologies. Oh my goodness. Here I am asking you all to come in last minute, and then there I have you waiting all lonely in the waiting room where there's nothing fun happening.
Your Honor, it is the opportunity to enjoy a cup of coffee and quiet with the door shut and
That's
writing notes to myself. That's heaven.
Oh, God bless you. Okay. This is, I just wanted to bring you on because we had an inquiry about jury sheets and other kinds of things, and it just brought a bunch of questions for us in terms of, well, not questions, but we just wanted some clarity since we're going to be I'm going to be out of pocket starting tomorrow. And I return on Tuesday, just in time for you all to get started. We have our docket call on Wednesday. But the inquiry was about juror sheets. I can tell you we're at the mercy of Jury Hall, of course, and the way they organize. I think generally we will get jury sheets anywhere between Friday and probably Tuesday before the trial setting. So
Okay.
I wish I could be more specific than that, but we're just, when they get it situated over there and they have a panel ready for us, they send it over. Let me double check something because we've been organizing multiple kind of back-to-back trial weeks here. Let's see, next week. Right, so we have courtroom and courtroom. So you all know, I don't know if I was clear about this, anticipating our trial, we have a panel of 60 in the morning and a panel of 60 at 1:30. Okay, that's just how the court has to schedule things sometimes in light of like our criminal trials where that's not enough. I'm fingers crossed that you all will be able to utilize just that one panel.
Yes, that's plenty of jurors.
Okay. Okay, so we may then, Mr. Nanez, cancel the afternoon panel, because if that helps Jury Hall put together people to get us our jury sheets quicker, then we're going to do that. I'm not really sure how Victor does his magic over there at Jury Hall, but if I can send him some names back and it helps him, maybe that'll expedite the request and we can get those to you sooner. It'll be in the courtroom, obviously, and so that was the next question. The seating chart is straightforward. We line them up actually right to left in the gallery. I believe they go 15. I might be wrong on that, but that's how we do it. And we can accommodate everybody there, nobody in the jury box. With respect to scheduling, we were remembering different things in terms of you all's availability. If you were able to get a jury on that morning panel on Thursday, are you prepared to start evidence that day?
Yes.
Wonderful. You just made my day, because we had some confusion as to there being some folks unavailable. So were we actually going to start on Monday? And that would have really pushed me back because my schedule is very tight. So I just want to make sure we're all on the same page. We get that jury in the morning, we'll probably get a lunch break and start first thing in the afternoon and go straight until we're done.
Yes, ma'am.
Yeah, okay. So
That's
in terms
perfect.
of the remote witnesses, the reason I had asked Mr. Nanez to work with you about scheduling a time the request, I believe, was can you all utilize your own Zoom meeting to bring in your witnesses? That's fine. I can just tell you, we really need to have some kind of dry run or practice run because the audio, although they've done a certain upgrade in the court, I want to make sure we don't have internet issues that are going to make the testimony choppy or anything like that. And I want to make sure that it is audible to the court reporter and the jury so that we're all set up. So I believe he offered Friday morning. I need you all to please do that or schedule something very soon that we can actually test it and make sure that it works so we don't have any hiccups. For some reason, it just never fails. It never fails. Make sure your witnesses, if they're in different time zones, know the time zone, all those kind of nice things that come up so that.
Your Honor, we have a conflicting hearing proceeding that includes the people on this case. And I'm wondering, would we be able, by any chance, would the court have any availability, say tomorrow afternoon or Friday afternoon? But tomorrow afternoon would be better, truthfully.
For
Or
what?
actually tomorrow morning to do a dry run.
So I'll start off by saying I won't be here. And I know we have a full docket. Judge Beasley is covering our docket in the morning tomorrow.
Okay.
So I think that would make it very difficult for Mr. Nanez to do that. The afternoon, is that what the request was, Mr. Rincon? I'm sorry.
Yes, Your Honor, tomorrow afternoon.
Okay, let me see the afternoon. I think there's a docket in the afternoon, but Ms. Hernandez, could you take care of the Zoom docket? So Mr. Nanez could work with folks if we need tomorrow afternoon. I think.
Yes,
Yeah. So I think we can do Thursday afternoon.
Yes, that sounds fabulous, Judge.
For those who that time doesn't work for, obviously Mr. Nanez still has that Friday slot open. So if you all need to do that, use whatever you can. We will work with you. Luckily, we were not in trial this week, so it didn't make us out of pocket. We have a little bit.
Great.
What else? I'm trying to think what else we have. How long do you all think this is gonna go?
Hopefully we'll be done by Wednesday would be my thought.
Okay.
Yeah, Wednesday, Thursday, I think probably is a good estimate.
Okay. All righty. I've made arrangements through Tuesday's a very busy day for us. We might have, I'll tell you on Monday. So we're starting on the 16th. On Monday, the 20th, we will have a slightly delayed start. I have a bench trial that should take about 2 hours that I'll start at 8. So anticipate we would start at about 10:30 on Monday.
Judge, do you usually adjourn right at 5:30 unless we're in the middle of a witness or something?
I will go as long as we need to, if everybody's okay with it. But if folks need to adjourn at 5, I will push things, I will push things. And if I think we can get quite a bit done by going to 6:30, if everybody's okay, if my jury's okay, if my folks are okay, my court reporter's okay, we will keep going.
Good. Okay, great.
So,
Works for us, Judge.
I had forgotten that I had that tax bench trial, and it's I hate to do a delay for you all, but we can generally make it up with, I could limit jury to exactly 1 hour, like we start in 1 hour for lunch, things like that. We just try and run it efficient. That's why I wanted to make sure we had the technical issues.
How much time do you usually give for board ire?
In a civil case? What would you be asking for in this one?
I don't know, 45 minutes, maybe an hour or something like that.
Oh, I was thinking half an hour, but I'll give you, I saw Mr. Moss nod his head, so I'll say 45.
I can do that.
Yeah, okay.
Yeah.
A little more than I used to it, but hey, that's okay. I don't think I'm excited. I would like to see all y'all in action. So
All right.
okay. So in the event we didn't get a jury off of that morning panel, I have a morning panel on Friday, but then that's kind of, I don't even want to say that. That's gonna give me a headache. Just know we do have one. Okay.
Right.
All right. All right. Thank you all. Is there anything you all needed from me other than that, the scheduling, the jury sheets?
No, Judge, we'll work out, I think, pretty much a lot of everything we need to with counsel.
Okay. Mr. Nanez, Ms. Hernandez are points of contact for any of those arrangements, questions. Like I said, I'll be out until Tuesday and it's going to be a mess when I come back. So you all are, I'm just setting you up. So I'll see you on I guess Wednesday we have our DACA call, right?
Got a lot
Yes.
of hearings. Yeah, a lot of motions, I believe, Your Honor. It's all been piled up on the day, so we may be there may have a little bit of time to spend.
Okay. All right.
Okay.
Sounds good. Thank you for showing up today, folks.
Thank you
All right,
so
thank
much.
you.
Look
Take
forward to
care.
it.
Yeah.
Bye-bye.
Bye-bye.
All right. Who else is in the waiting room?
Nobody, Judge.
Nobody?
No, ma'am.
So, okay, let's get off of YouTube then.